Welcome. We're going to give it just a minute for everybody to get in, and then we'll get started. Good afternoon. Welcome to our webinar today. If I can just make sure everybody's got their phones on mute, just to minimize the background noise, I'd appreciate it. My name's Laura Beckman. I'm the chair of the Consumer Tenant Committee of the Public Interest Law section. And we encourage everybody to join the Public Interest Law section if you're not already a member. And we're very proud today to have our third webinar in our series, Lender Force-Placed Insurance Litigation, presented by Dennis Wall. We have one more webinar in our series, and that one will be on October 24th, and that will be on standing and attorney fees and foreclosure and debt collection cases, where we'll be talking about the Glass and the Bushnell cases. So that registration information will be coming out shortly. We encourage you to sign up for that one as well. A huge thank you to the Legal Services of North Florida, who has organized this webinar for us and is hosting it. We're deeply indebted to them for helping to make these free webinars possible. On your GoToWebinar box, there should be a place for you to be able to post questions. So if you have questions, please go ahead and post those. I'll be monitoring those throughout the webinar, but we should have time at the end as well to answer any questions that you might have. Please join me in welcoming Dennis Wall. We're very grateful to Dennis today for presenting on this topic. Dennis has over 40 years of experience in this area. He's an AV-rated attorney who's owned his own firm for the past 25 years, where he's practiced insurance law. He served as both an expert and a consultant, an expert witness and a consultant on insurance issues. And he's a prolific writer on this topic as well. He's published 4 books and published numerous articles about insurance. So we are very grateful to have him today talking about something that he is very familiar with and will help shed some light for the rest of us on lender force-placed insurance. Dennis?
Thank you, Laura. Welcome to Lender Force-Placed Insurance Litigation and the Filed Rate Doctrine in Florida webinar. It lends credibility to the things I'm about to say, since I've written a book about it. There's a list of my many articles on the subject. In all seriousness, there is an article coming out in LexisNexis, New Appelman Current Critical Issues in Insurance Law, on filed insurance rates, which we're going to cover at the end of this program. Yesterday, there was a decision by the 11th Circuit Court of Appeals in a 2-to-1 decision involving Florida law, which we're going to talk about as well, with the benefit of having read the 65 pages of that decision before today. What lender force-placed insurance is. Bear with me. This is elementary for some people, but I'm going to start from the beginning. Most people agree in a loan contract to pay for force-placed insurance. They just may not be aware of it. The borrowers pay the premiums on LFPI. The insurance is intended to protect the collateral. I'm getting the sound of a washing machine here. If anybody has a washing machine going, could they please mute it? Thank you. The purpose of the insurance is to protect the collateral, to buy insurance to protect the collateral. That's what a borrower is required to do and what lenders require them to do. It makes sense. And if we do not maintain the insurance to protect the collateral, which we have agreed to purchase to protect the collateral, then the lender has a contractual right, in that case, this is a plan B, to understandably place insurance by force to protect the collateral. In any case, the borrower pays the premium. So it's accurate in this case to say that really what we're talking about is not just force-placed insurance, but a force-placed insurance premium or force-placed insurance charges. So we agree to LFPI, lender force-placed insurance, if we do not make the loan payments or we do not keep insurance in place. Let me add this kind of caveat. If we do not provide satisfactory evidence to the lender that we do have insurance in place, there's a difference. Sometimes lenders impose force-placed insurance when there really is insurance in place. As we will come to, that's called unnecessary insurance. That's a claim in LFPI cases. It is standard procedure in Fannie Mae and Freddie Mac mortgage forms to provide for the lender to force place insurance to protect the collateral. But we generally do not agree to pay for add-ons. Most mortgage contracts talk about insurance which is necessary or which is reasonable and appropriate to be placed by the lender to protect the lender's interest in the collateral. Well, we don't agree to pay for additional prices for such things as kickbacks, for tracking services to track whether the insurance is in place to protect the collateral. That is a cost of doing business. Or for reinsurance premiums or agents' fees for non-existent agent services, or for premiums which are really penalties, not charges for insurance. Our focus on LFPI will focus on a forensic investigation of the cases and what the party testified, what the documents displayed, not what the attorneys argued. As anybody who has been to even one trial knows, what the attorneys say in opening and closing arguments is not evidence. Well, what attorneys say generally is not evidence, it's simply an argument. I'm going to concentrate on what the parties testified, what the documents displayed. The information that I'm going to address is made available by courts in unsealed files. For example, exhibits to pleadings, which are so hard to find, we'll come back to that in a second. And officially reported and not officially unreported judicial decisions, deposition, interrogatory answers, affidavits and declarations, and allegations and complaints and answers. Now, it is really difficult in the first place when you go to PACER, the Public Access to Federal Courts Electronic Records, to look at the exhibits, to try to find testimony, affidavits, declarations, answers to interrogatories and such. And clerks, many clerks, simply label an exhibit, say, to a motion for summary judgment as exhibit number 1 or exhibit number 2. There are thousands of exhibits in any court file, and multiply that by the number of different cases that are in the court files. They're really difficult to find. That's without the benefit of secrecy stipulations in these files, which are becoming more and more the practice. Some of the stories deliberately kept a secret by stipulations and other agreements, and all of the lawsuits which I have taken a look at during the past 5 years. It's probably more than 5 years, but I'm going to stay 5 years. Enough of the information has been made public to allow the observations presented here of the business practices in the lawsuits, including the LFPI practices widely alleged in the cases. And again, if it's difficult enough in litigation going through PACER to find where the evidence really is located, it's even more difficult when there's no lawsuit. The complaints in LFPI cases. LFPI lawsuits are not successful when they present allegations seeking damages on account of or challenging lenders' contractual rights. Lawsuits survive motions to dismiss by filing complaints which instead allege these add-ons that are not authorized by the loan contract or not made necessary or reasonable or appropriate by the mortgage loan contract. These lawsuits damages the successful ones that survive motions to dismiss for the increase in LFPI premiums and charges that are allegedly added to the borrower's homeowner's monthly mortgage payment. Crucial features of LFPI is that it ordinarily protects the lenders and not the borrowers, and it is always paid by the borrowers, and it is always placed by lenders. Not sometimes, not generally, but always paid by borrowers and always placed by lenders. LFPI practices changed during the Great Recession or as a result of the Great Recession. They changed from producing protection to producing revenue. As one lender's attorneys argued in an LFPI court case, this is a quote from a case filing on behalf of a lender. The lender's point of view is that its best economic interest is to generate revenue from a loan rather than have repayment of the principal balance of the loan. Business practice at work behind LFPI practices. We've looked at LFPI practices. Now take a look at the results. 13 major banks, including both depository and investment banks, issued $2 trillion in residential mortgage-backed securities between 2005 and 2008. Those numbers are used because those are the numbers we have available. We are not supposed to know the numbers in existence today or yesterday or the last year, partly because we're not supposed to know. The lenders don't want us to know, and the servicers and the insurance companies that provide the force-placed insurance product don't want us to know. In addition, there are the stipulations that I talked about that provide for secrecy of this evidence. Well, the total settlements of the $2 trillion in residential mortgage-backed securities, the cost of producing that revenue was approximately $120 billion when considered in the context of settlements with federal agents, with agencies of the United States government. Now, that cost of doing business, the cost of settlements of claims brought by agencies of the federal government is 2%. That is 2% of the revenue generated in that line of business between 2005 and 2008. One lender servicer, according to the corporate representative's deposition testimony, received commissions on $400,000 in LFPI aggregate premium for each year between 2008 and projected for 2011. Now, the total amount of that period of 4 years is $1.6 billion. That's how much commissions one lender servicer, that's how much LFPI was placed by one lender servicer during those 4 years. On the next slide, slide 17, we'll see the commissions it received. 11%. 11% of $1.6 billion is $176 million. Now, to summarize what we know from these facts, from this evidence, 1, force-placed insurance carriers' commissions to one lender's captive insurance agent in the 4 years from 2008 through 2011, according to the publicly available deposition testimony, was $176 million. That's one lender servicer. As for the amount of reinsurance premiums that are at issue in lender force-placed insurance practices, we don't have publicly available pleadings or testimony or documentary evidence or periodicals or books located that I can find. However, there is a motion for an award of attorney's fees in an LFPI case in the Southern District of Florida, in fact, that represented to the court that the lender in that case, the one lender, which is a different one from the one I mentioned earlier, received more than $600 million in reinsurance agreements revenue for 6 years, between January 1, 2008 and October 4, 2013. The average of those over those roughly 6 years was, of course, $100 million per year for one lender from one line, namely reinsurance premiums. As far as backdating, excessive policy limits, and other unnecessary insurance, we don't know. There are insufficient numbers of pleadings and testimony and documentary evidence from which to gauge amounts or even guess at amounts reasonably. But again, we're not supposed to know. It's not good for business if we know. And secrecy stipulations prevent us from knowing. We do have a couple of examples of claims in LFPI cases. We have an example of unnecessary insurance. We have an allegation of $1,575 charged on a HELOC or home equity line of credit that had a zero balance. So there was nothing to protect, but the borrower was charged $1,575 in force-placed insurance charges. A second example, an allegedly unnecessarily high policy limit. The FPI policy at issue in that case had a policy limit of $253,000. In excess of that, an annual premium in excess of $5,000, but the original loan amount before the borrower made any payments was $159,000. And that amount of $159,000 was the only amount the homeowner borrowed. So we have a force-placed insurance policy with a coverage limit nearly $100,000 more than the original loan amount, even in that case. As anyone knows who has paid for insurance, the higher the limit, the higher the premium you pay. The third fact example is on slide 22. There were two binders of FPI flood insurance in that case. One was a 90-day binder with a premium of $893 for a policy limit of $250,000. The second binder was also 90 days, also for $250,000, and it had a premium of $780.90. The original amount of the homeowner's loan in that case was just in excess of $115,000, 115. The unpaid balance at the time that the force-placed insurance was imposed was approximately $113,000. So we have insurance imposed with limits of $250,000 to protect an unpaid balance of $113,000. Another example of unnecessary insurance, unnecessary limits. There are many alleged causes of action in LFPI cases. Some are common law causes of action, some are statutory claims under federal and state statutes, and the most frequently alleged cause of action or claim in LFPI cases is breach of contract. A breach of contract cause of action generally is successful in withstanding motions to dismiss in LFPI cases when it is alleged against a lender or those standing in the shoes of the lender that the lender allegedly has breached the contract by imposing any of these kinds of unnecessary, unauthorized, inappropriate charges. I have an asterisk to remind you that none of these cases presenting lender force-placed insurance claims only has been found which ever went to trial. So we have to rest our case as it were on the allegations because we don't have the evidence. There are cases anecdotally that have gone to trial that involve claims including lender force-placed insurance claims, but I haven't found one that went to trial that involved only lender force-placed insurance claims. I predict, as I say in slide 25, that perhaps the most interesting federal statutory claim is TILA, the Truth in Lending Act. In basic terms, even before Dodd-Frank, which did affect the Truth in Lending Act, it was required that the creditor disclose the credit's finance charges, the amount financed, annual percentage rates, and insurance premiums, among other things, before the credit would be extended. TILA's role in LFPI is this: when insurance is placed by force without authorization and in violation of the loan contract, such as where the insurance premium allegedly includes kickbacks, the great majority of courts require disclosure under TILA even without considering the Dodd-Frank amendments. Since Dodd-Frank is under attack at the present time, as everyone knows, it's being watered down, repealed, amended, then we can put Dodd-Frank aside for our analysis and talk about, well, what does the Truth in Lending Act pre-Dodd-Frank require? Well, it required disclosure of the unauthorized, unnecessary, inappropriate charges because they were part of the extension of credit. Therefore, the majority of courts denied and continue to deny motions to dismiss TILA claims in LFPI cases. My prediction is buttressed by a couple of more reasons. They come from the Truth in Lending Act itself. First, there's original jurisdiction in the federal district courts. There is concurrent jurisdiction in state courts. So these actions can be filed, these claims can be filed either in federal or in state courts. Second, where a given disclosure was required as a matter of law, the only remaining fact question is whether the disclosure was sufficient. Now, if no disclosure was made at all and TILA is held to apply, we're just left with a legal question, which is whether TILA applies. Because if there's no disclosure of the unearned commissions or the kickbacks or the reinsurance that pays for nothing, then the only remaining question is a question of law in that case, which is whether the Truth in Lending Act applies to the situation in the case. Third, Individuals with comparatively small damages claims in LFPI cases can recover actual damages plus what amount to statutory penalties within a range not less than $400 or greater than $4,000. In a class action, the amounts that can be recovered are even greater. On slide 29, we talk about the role of recovery of attorney's fees and costs. In the case of any successful action under TILA, the plaintiff can recover costs together with a reasonable attorney's fee as determined by the court. TILA statute of limitations. It's kind of interesting. The TILA actions may be brought within 1 year from the date of occurrence of the violation, except Dodd-Frank changed that a bit. They changed that in some circumstances, which I'm not going to go into, it's going into the weeds, they extended the statute of limitations from 1 to 3 years in certain cases, but still beginning on the date of the occurrence of the violation. So the key in either case, a 1-year statute or a 3-year period, is beginning on the date of the occurrence of the violation. This does not mean beginning on the date the Great Recession began in 2007 or 2008. It means we go back from the date the lawsuit is filed, either 1 year or 3 years, to see if there's a date that falls within that period on which a violation of the TILA occurred. To put it another way, do we have a date that began, or the occurrence of the violation that took place during the period of 1 year or 3 years, as the case may be, before the suit was filed? There are also causes of action, another example, under a state statute in an LFPI case. And the example I've chosen is the Florida Deceptive and Unfair Trade Practices Act, or FDUTPA. You may pronounce it differently, and you're allowed to. The statutes are given there. There are 3 basic elements: a descriptive act or unfair practice, causation, and actual damages. The allegations of conduct for a FDUTPA violation have to be different from and in addition to conduct authorized by the contract. LFPI cases are a fit for that because, let me go back to that idea, the conduct alleged in LFPI cases is different from and in addition to conduct authorized by the contract. The very essence, the gist, the gravamen of LFPI cases, any of those words, describe the same thing. That's what it's all about. Unauthorized charges, unnecessary and inappropriate charges that have been passed on by lenders and servicers and force-placed insurance carriers to homeowners. It is conduct not authorized by the contract. So it is a good fit for a Truth in Lending Act violation allegation. FDUTPA reaches LFPI practices. Looks like I was kind of getting ahead of myself here. Defendants in the case law include mortgage servicers and lenders. There are no procedural limitations, meaning the universe, the set of defendants that can possibly be accused of FDUTPA violations may or may not be limited to mortgage servicers and lenders, but certainly the claims are good under state Deceptive and Unfair Trade Practices Act claims against servicers and lenders. Examples of allegations withstanding motions to dismiss under FDUTPA in LFPI cases that are similar to grounds advanced under other states' Deceptive and Unfair Trade Practices Acts include a commission arrangement or failing to seek competitive bids in the open market, backdating policies, and taking kickbacks. Deceptive and Unfair Trade Practices Acts are in a category of consumer protection statutes. Accordingly, for that reason, they authorize recovery of attorney's fees in addition to actual damages. In Florida, it is not required that the fees be proportional to the recovery. For example, the Bull Motors case on slide 34 involved a $5,626 award and $62,000 in attorney's fees. It was not required, said the court, that the attorney's fees award had to be proportional to the fees recovered. And in addition, the lodestar enhancement of attorney's fees is available in Florida under our Deceptive and Unfair Trade Practices Act. Back to secrecy stipulations in LFPI cases for a moment. Typical secrecy stipulations in litigation, including LFPI litigation, provide that parties mark confidential materials. Discovery under those stipulations doesn't have a shelf life, meaning they don't have a life beyond the particular case. Parties and non-parties, such as expert witnesses, will only use that material in the pending case. That's why it's never given out to the public, never given out to lawyers in any other case, or parties, or anyone else. At the end of the case, under these stipulations, the parties and attorneys involved all return it to the defendant's attorneys or the defendant from whom they got it. Now, what is the effect of all these stipulations on knowing what is in the public court file? Shh, it's a secret. Although the default presumption is openness of court records. More LFPI litigation and practices are available on YouTube. Today, it's on to talk about the filed rate doctrine, particularly since we had the arrival yesterday of a decision, 2-1 decision, by a panel of the 11th Circuit Court of Appeals on Florida law, written by a judge from the 6th Circuit telling us what Florida law is all about. But more litigation and practices, the LFPI litigation and practices are available on YouTube. I've given the site or the link on slide 37. But for today, it's on to the filed rate doctrine. The filed rate doctrine. I want to talk about what it is, what it does. Is there a filed insurance rate doctrine in Florida? And is there a filed rate doctrine in Florida LFPI cases? First, what it is. It is judge-made. This is a very important, crucial opening concept. It is made by judges and it can be changed by judges. Judges need to know that. They're not just handed the stone tablets with the 10 Commandments written on them. They didn't receive these on Mount Sinai. This is judge-made. It's written by judges. It can be changed by judges. And maybe you don't want to say this directly to a judge in your case, but judges can be wrong. The doctrine began in federal courts. The first cases involved federal agencies regulating utilities. The utilities filed rates for regulatory approval. When they received the approval of the authorized federal agency that reviewed and approved or disapproved the filed rate, the federal judges held that those rates would be the only lawful rates that were at issue. They couldn't be challenged. They couldn't even be challenged. Approved rates could not even be challenged collaterally. For example, where the damages assessment or calculation may call into question a rate that was approved by an authorized agency, federal courts would not hear the case because of the filed rate doctrine. Anything involving a recalculation of rates approved by federal agencies would not be decided by federal courts. But as I ask on slide 40, what is the file rate extended? But is it extended to insurance? Insurance is regulated by state agencies. If it's regulated at all, certainly we do know this. It is not, insurance is not regulated by federal agencies. The two strands of the filed rate doctrine, at least as developed in federal courts, are non-justiciability and non-discrimination. Non-justiciability means that it is not an appropriate controversy for the federal court to adjudicate. Non-discrimination means what I had said before, that the rate, if it cannot be collaterally attacked by a particular ratepayer, because if the ratepayer is successful in recovering damages from the utility, then in effect, that particular ratepayer receives a lower rate for its payment than other ratepayers who did not sue the utility. And so discrimination is the result in the eyes of federal judges. Either one of those strands, as they call them, is enough. And non-justiciability is a favorite of judges in this judge-made doctrine. What the file rate doctrine does, FRD. The FRD is a defense. It's an affirmative defense. The FRD applies when the charge involved in the case is regulated as part of a file rate by an agency authorized to regulate it. The FRD does not apply when the charge at issue is not regulated. The Florida Municipal Power decision that I cite there is instructive. I think that the first takeaway is at the bottom. Look hard at whether the charge at issue is regulated. There, something called point-to-point service was admittedly regulated, but the plaintiff was complaining about network transmission charges. And as the court said at page 616, there was no filed network rate. So the filed rate doctrine could not apply to that situation. Another important takeaway from Florida Municipal Power is more or less in the middle of that slide, 42, that the characterization of the plaintiff's claim is therefore critical to whether the filed rate doctrine will apply. To the extent that the plaintiff's claims look to a judge like they are challenging the rate that has been charged to a person, then that judge is inclined to apply the filed rate doctrine to prevent the plaintiff from changing that rate. It's as simple as that. Therefore, the characterization of the plaintiff's claim is critical to whether the filed rate doctrine will apply. Is there a filed insurance rate doctrine in Florida? This is a related question. LFBI cases, after all, involve insurance. So one response to the filed rate doctrine in LFBI cases is a response for all insurance cases. If insurance rates are regulated by a state, then that state's law regulates the filed rate doctrine. On the other hand, if insurance rates are not regulated by the state, then there is no filed insurance rate doctrine to apply. Title insurance cases provide examples of this, where states regulated rates for title insurance, the filed rate doctrine might apply. In other cases, the filed rate doctrine could not apply because states did not regulate the insurance rates for title insurance. Does the filed rate doctrine apply in LFBI cases in Florida? First, where are the LFBI cases in Florida? Now, answering the second question first, most of the LFBI cases in Florida have been filed in the Southern District of Florida. And so far, the filed rate doctrine has come up only in cases in the U.S. District Court for the Southern District of Florida, I have to add, until yesterday, when the 11th Circuit Court of Appeals, a panel, 2-to-1 panel, 2 judges decided that the filed rate doctrine also came up in that case on appeal, which they decided in Atlanta. There's a split in authority in the Southern District of Florida. First, the older, I put that in quotes, Southern District of Florida cases, and I put the older in quotes for a reason. The line of demarcation between the cases in the Southern District is really the decision in Rothstein versus Balboa Insurance Company, a decision by the Second Circuit in New York in 2015. Then in that case, in Rothstein, the appellate court looked at the issue of the filed rate doctrine in a case involving the laws of 3 states, New Hampshire, New York, and Texas. Now, the procedural question there was really not addressed, but it is a procedural question that came up in Wilson versus Everbank, also on slide 45, and that is, can you raise the filed rate doctrine, and can it be successful at the motion to dismiss stage? Well, think of it, a motion to dismiss is usually accompanied in these LFBI cases by declarations and affidavits with exhibits. It's my understanding of procedure that when that happens, the motion to dismiss is converted into a motion for summary judgment, and it's governed by different standards. And yet, in LFBI cases, as in many other cases, the federal judges apply the plausibility standard of a motion to dismiss and not the is there a genuine issue of material fact standard of a motion for summary judgment. Moreover, the materials attached to the declarations and affidavits, it seems to me, are subject to attack. Again, as I understand it, based on, let's say, hearsay, not just hearsay of the declarant, but hearsay of the attachment, which, after all, are not the complete insurance rate filing by a given carrier in any given case, but are parts or excerpts with no substantiation of that they reflect in any way everything that could be reflected by the entire rate filing. At any rate, the line of demarcation for in the Southern District of Florida, is the Second Circuit's decision in 2015, and then we come to the post-Rothstein cases, if you will, applying federal FRD to state-regulated insurance. In these cases, on slide 46, yes, the filed rate doctrine applies to LFPI cases. The Fowler case mentioned there and Patel, the second case mentioned there, went up together on appeal. They were combined for appellate purposes, and a 65-page decision was issued yesterday by 2 judges and one judge dissenting in the appeal in that case. But before I get to my quick thoughts about the Fowler-Patel appellate decision of the 11th Circuit, let's go to slide 47. Suppose the filed insurance rate doctrine in Florida is a federal doctrine after all, and I have an asterisk. Here's my question. What if the federal judges decide that the filed rate doctrine prohibits LFPI cases, as they have done in the Southern District of Florida cases, the recent ones since 2015? But suppose a LFPI case is filed in Florida State Court, and suppose a Florida State judge decides that there either is no force-placed insurance doctrine in Florida, or there is no force-placed insurance doctrine in Florida that applies to LFPI cases. So there's a controversy, a distinction, a dispute between federal courts and state courts of whether the federal filed rate doctrine, applies. Well, going back to the idea that the filed insurance rate doctrine is a federal doctrine, sticking with that idea, assuming that to be the case, that would mean the real issue is whether Florida regulates lender force-placed insurance premiums, including kickbacks and other unauthorized charges. That being the case, the Florida Insurance Commissioner would still be instructive, maybe even determinative, certainly a person of interest on the issue of whether Florida recognizes the filed rate doctrine. I filed an amicus brief in Fowler, which was to show that the Florida Office of Insurance Regulation, the Florida Insurance Commissioner, as I'm sure you know, has taken the position that commissions or alternatively kickbacks and other unauthorized costs and charges are not approved as part of a filed insurance rate for LFPI premiums in Florida. I provided links in the amicus brief, which was filed on behalf of United policyholders on behalf of the appellants in the Fowler case, to each and every one of these consent orders, and now I'm providing these to you, slide 49. These are links to where you can access, and I checked out the links as late as yesterday. In fact, I checked out one of them this morning. They're still good. Those are the links to the decisions of the Florida Insurance Commissioner. Now, I have to say, this is what I would call C sites, C signals, S-E-E. And by that I mean this is authority that does not state the ruling or the decision or the proposition that it stands for, but strongly suggests it. I have in my hands the ASIC consent order. ASIC agreed in the consent order in paragraph 5, for those interested in the citations, to not pay commissions to a servicer or to a person or entity with a servicer on LFPI policies obtained by that servicer, ASIC agreed not to issue lender force-placed insurance on mortgage property serviced by a servicer that is an affiliate of ASIC. ASIC, by the way, stands for American Security Insurance Company, and it happens to be perhaps the largest provider of force-placed insurance policies in the country. ASIC also agreed with the Florida Insurance Commissioner that it shall not reinsure LFPI policies with a captive insurer of any of its servicers, among other things. In exchange for that agreement, the Florida Office of Insurance Regulation, the Florida Insurance Commissioner, disapproved ASIC's previous application for a rate. However, as a part of this consent order, ASIC agreed to refile its collateral protection program with the Office of Insurance Regulation. It is true that it is provided in paragraph 13, again, if you're interested in citations, that ASIC agreed that the failure to adhere to one or more of the above terms and conditions of this consent order shall constitute a violation of a lawful order of the office and shall subject ASIC to administrative action by the office. That is not, I think, a bar on jurisdiction. We are not, in LFPI cases, I think, the allegations in LFPI cases are not attempting to enforce consent orders. The role of a consent order of this kind is pretty clear, and I'll try to lay it out. Based on the Cannon decision, also cited on slide 49, it is clear that the Florida Insurance Commissioner, the Office of Insurance Regulation, would not even have been willing to approve rates in the future, and that it declined to approve, it rejected a rate filing at this time because ASIC could not guarantee that in that rate filing, these unauthorized charges were not included. To get the Office of Insurance Regulation's approval in the future, ASIC would have to not include and agreed not to include these unauthorized, unnecessary, inappropriate charges. An analogous argument or an analogous situation was presented in Cannon in the Northern District of California. In that case, ASIC raised a ruling or consent order with the California Insurance Commissioner in its favor as an approval of its commissions, which included alleged kickbacks or alleged commissions that it took from its force-placed insurance providers. The district judge in that case declined to apply the filed rate doctrine, in fact, pointing out that in the course of the consent order, the California Insurance Commissioner said that he did not have jurisdiction to decide, he was not authorized to decide whether the rate filing in question included unauthorized charges that would be billed to homeowners and borrowers in their mortgage contracts. He was simply approving the filed rates at that time. In that context, the federal judge said the filed rate doctrine would not apply, particularly, I believe, on a motion to dismiss. Now, to slide 50. Recall I mentioned the difficulty in finding unsealed testimony and other evidence in these court files. I want to ask your help. I want to ask your help in locating unsealed testimony and other evidence in recent LFPI case files in Florida and anywhere else in the US. I'm writing another article about force-placed insurance, and it is not so easy now to find discovery in the court files on PACER as it once was. Do you know of force-placed insurance cases with depositions and other discovery accessible on PACER? Do you know who would know that I can ask? And if you know, here's my email, including if you have any questions after the program ends. DJW, which stands for my initials, Dennis J. Wall, at dennisjwall.com. This is 2018, and I am my own website. On to Fowler Patel, the decision of the 11th Circuit panel yesterday, September the 24th. I received it late yesterday, so please bear with me. There were facts and allegations, songs and lamentations in that decision. I want to take a while to mention some of them. The two judges who wrote the majority opinion, which was actually written by a Sixth Circuit judge. A lot of out-of-circuit judges involved in this decision on Florida law, but said that a simple framework emerges for determining whether the filed rate doctrine bars a cause of action. Here, this amounts to a determination of whether the plaintiffs worded their complaints. Remember I said you have to avoid, successful LFBI cases avoid having judges think or perceive that the claims at issue are challenging the rates. Here, this amounts to a determination of whether the plaintiffs worded their complaints as a challenge to ASIC's rate for force-placed insurance. If they did, then their causes of action are barred. Second, if the complaint does not facially attack a filed rate, we must ask whether it implicates the non-justiciability principle by challenging the components of a filed rate. Only if the answer to both inquiries is no is the filed rate doctrine inapplicable. Interestingly, the two judges said to the one dissenting judge who's from Florida that the dissent could not mean that the filed rate doctrine is a federal doctrine that only applies to rates approved by federal regulatory agencies. I submit to you, based on what we've been talking about, that's exactly the point. This is an imposition of federal law and federal doctrine on Florida state law questions. And I think the cases present that issue, which is sometimes, as we see, ignored by federal judges. The two-judge majority continued, given, moreover, that the plaintiffs repeatedly used the language of market manipulation to characterize their causes of action, citing to the complaints, we cannot avoid the conclusion that they are directly challenging the rates that ASIC has filed with state regulators. Their complaints, therefore, contain textbook examples of the sorts of claims that we have previously held are barred by the non-justiciability principle. Remember, I said, don't let the judge think that the case involves a challenge to filed rates. If the judge decides that, the case is pretty much over, and at least in federal court. And certainly it would be over in the Southern District of Florida, and it would be over as long as Fowler and Patel is allowed to remain good law. It would be the case throughout the 11th Circuit, because this was an appeal in Fowler and in Patel for motions to dismiss. There was no evidence presented, except the evidence that was allowed as attachments to the motions to dismiss. Now, Judge Jordan from Florida dissented. He said, and he really concisely summarized the whole issue. The federal filed rate doctrine, a creature of federal common law derived from various federal statutes, has been around since 1907. Despite its existence for over 100 years, Pennsylvania, which one of the plaintiffs was from Pennsylvania in those cases, and Florida have so far not adopted it. The majority, without seeking guidance from the Supreme Courts of Pennsylvania or Florida, now confidently decrees that the federal filed rate doctrine is the governing rule in these two states. The majority also expands the filed rate doctrine to also bar claims against anyone whose contract seemingly concerns a filed rate. The majority then applies its sweeping rule to parties which have not filed any rates with state regulators. The dissent also noted, by engaging in side agreements with ASIC for commissions and reinsurance and other kickbacks, transactions that are, of course, unregulated, the lenders, in those cases, found a way to discount their insurance costs. What the dissent was talking about there was that the lenders and servicers and others took side agreements with the carriers for payment of commissions and reinsurance and other kickbacks, unauthorized charges, and kept the filed rate, but received the discounts on the side, which was not filed as a part of the filed rate filing with the Florida Office of Insurance Regulation. This is an interesting concept in that nowhere in the Fowler-Patel opinion did they even mention the Florida Office of Insurance Regulations consent orders with lender force-based insurance carriers, including one of the carriers at issue in the case in front of them, ASIC. The dissent continued, given that the mortgage contracts between the homeowners and the lenders required the lenders to charge the homeowners for only the cost of insurance, the lenders allegedly breached those contracts by demanding costs that were more than the discounted costs they paid to ASIC. So, in the dissent's point of view, the file rate doctrine wouldn't apply even if it was just a federal file rate doctrine. Fowler provides us with a new opportunity. Two things that come to mind. One is, what we have been told is a definition of insanity is doing the same thing over and over again and expecting a different result. The second thing that comes to mind is something that my mother always told me, which is if you find obstacles in your way to getting something done, to doing something, that's God's way of telling you maybe not to go there. I would suggest that any filing of lender force-placed insurance practice cases will be welcomed by defendants if they are filed in federal courts within the 11th Circuit after this decision, because all of those claims will be barred. All of the claims raised by the plaintiffs in Patel and Fowler were barred on motions to dismiss because of this federal filed rate doctrine. So refiling in federal court or filing these cases in federal courts is more of the same, and I don't think we have any reasonable expectation of a different result. In addition, I would think that if defendants welcome these lawsuits being filed in federal courts, homeowners may be better off and their attorneys be better off if these lawsuits would be filed in state courts under state claims and causes of action. For example, one that comes to mind is the Florida Deceptive and Unfair Trade Practices Act that I've talked about in this webinar. The issue of whether there's a filed rate doctrine in Florida or a filed insurance rate doctrine in Florida, or if there is any such filed insurance rate doctrine in Florida, does it apply to LFPI cases in Florida, could and would be decided by Florida judges interpreting Florida law, not imposing out-of-circuit law in federal courts. Now, who and how and what in the future Florida LFPI litigation as a result of Patel Fowler now, whatever is involved in that presentation of claims and arguments and cases, it will be you. As far as I am concerned personally, I really enjoyed doing this webinar, and I think now that's as much as I would like to be involved with it. And I would accept, of course, to answer your questions. So I would turn this over to Laura, if she's there within hearing range, and John Fenno, and see if there have been any questions. And if not, then as they say at the end of a hearing, we're done.
Thanks, Dennis. I am here, and it doesn't look like we have had any questions. So if there are no further questions, Dennis, if you can give the controls back over to John. We've got the CLE information to post for everyone. Thank you all for attending today. We greatly appreciate you participating in this webinar with us. And just a reminder to please join the public interest law section if you're not already a member. Please sign up for a pro bono case with Legal Services of North Florida or any of your local legal aid providers. And please sign up for our last webinar in the series in October, and we look forward to seeing you all then. Thank you all very much.